a couple of things that I think are fascinating about this, and if you've been listening to this or watching it on TV, most of the networks are carrying it, and it's been carried live all over the place. My guess, well, you know, it's hard to guess. My guess is that what the Supreme Court is trying to do here is figure out a way to keep Trump on the ballot and yet not establish some precedent that might come back to haunt, you know, them and the whole country and whatnot. A couple of weird little nuance things that I caught. Judge Gorsuch, for example. Well, here's, and I can't say this happened every single time, but the lawyers for Trump referred to him as President Trump. The lawyers for Colorado referred to him as former President Trump. And Gorsuch says, President Trump, or as you prefer to call him, former President Trump, which just blew my mind when I heard that. I was like, wait a minute, Gorsuch thinks Trump is still president too? So, you know, there's like, this court is bizarre. 3 members of this court were on the Bush, you know, were on the Bush team, the Bush legal team, helping George W. Bush overturn the 2000 election that Al Gore very clearly won by thousands of votes down in Florida once the recount was done a year later. But the Supreme Court stopped that recount because the recount would have revealed that Katherine Harris and Jeb Bush had basically committed a crime. They had decided that any ballot that somebody said, you know, punch the button for Al Gore and then wrote Al Gore on the ballot to make sure that everybody knew what they wanted. There was about 30,000 more of those for Al Gore than there was for George W. Bush. And so Katherine Harris said, we're just going to throw those all out. We're going to call them spoiled ballots. We're going to create a whole brand new category. The recount identified that and showed that beyond any shadow of a doubt, Al Gore won the election in 2000 in Florida, which meant that he won the Electoral College, which meant he won nationally, plus he won the national popular vote by more than 500,000 votes. But the Supreme Court shut it down. And they did it because you had, you know, a bunch of corrupted people on the Supreme Court. This is what I wrote about in my op-ed today, the Hartmann Report op-ed, is that, you know, you had Clarence Thomas, whose wife was taking applications for positions in the Bush White House at the time that Clarence Thomas became the deciding vote in handing the election to George Bush instead of allowing a recount in Florida that would have handed the election to Al Gore. You had Scalia, Anthony Scalia, whose son was deeply involved with the Bush campaign. You had, and in fact, his son's boss was arguing on behalf of the Bush campaign before the Supreme Court. You had Sandra Day O'Connor, who had expressed to a number of friends that she wanted to shut this thing down and give George W. Bush the presidency because her husband had Alzheimer's and she wanted to resign, but she did not want a Democratic president, specifically Al Gore, to appoint her replacement. I mean, this is just a corrupt court. And now you've got Clarence Thomas again sitting there, you know, like the cat that just ate the bird. His wife was involved in the insurrection. And he's arguing, well, maybe it wasn't an insurrection, who knows, you know. But anyhow, the basic issues and so therefore I'm not expecting that the Supreme Court is going to rule in a way that is consistent with law or consistent with what's best for the United States. I believe that this court, or at least the 6 Republicans on this court, will rule in a way that is consistent with Donald Trump. I'm fully expecting that, based on what I heard this morning. You know, now I might be wrong, we'll see. But, you know, there's a couple of options. They can say, you know, Trump committed an insurrection, he's not eligible, end of discussion. As I said, I consider that extremely unlikely, given how much pushback on each one of these technical points, which I'll get to in just a second, we were hearing from the various justices, the Republican appointee justices on the court. The second option is that the court could say, you know, this isn't really our battle. The 14th Amendment, Section 3 of the 14th Amendment says Congress can remove this disability. Congress can meet and they can say, you know, Trump, even if he committed insurrection, he's still eligible to be president. They haven't done that, but, you know, it's well, so we're just going to leave it to the states, or something like, you know, we're going to leave it to Congress, I guess would be option 2. Option 3 could be they'll say, well, you know, we're just going to toss it to the states because Article 2 is, you know, quite clear. Article 1 and Article 2 are quite clear that the states run elections. So it's up to the states. Colorado doesn't want him on the ballot. That's fine. If, you know, Arizona wants him on the ballot, that's cool too. And, you know, I suppose the final option would be that the court would say, you know, this isn't even something that we should be ruling on. Well, I guess that's a variation on option 2, you know, that's up to Congress. So here are the basic arguments, and then I'm going to open the phone lines and just toss it to you, particularly the lawyers who are, you know, we've got a lot of lawyers who listen to this program. I would love to hear your thoughts on what you have heard so far on this. And so here it is. First of all, question number 1, is Trump an officer of the United States? Because the 14th Amendment says anybody who commits insurrection, any officer of the United States who commits insurrection can't hold office. And Trump says he's not an officer of the United States. President is not an officer. His legal team's brief says officer of the United States appears several other times in the Constitution in contexts that specifically exclude the president. Now, the Colorado Attorney General and Secretary of State and the Colorado Supreme Court said that because the Constitution cites the presidency as an office of the United States 20 times in the Constitution, it makes sense that the president is an officer. After all, he's holding an office. And the district judge in Colorado, who ruled in Trump's favor, essentially, leave him on the ballot, agreed that with Trump that he was not an officer. The Colorado Supreme Court, though, said, yes, he is an officer. So that's the first issue that they're arguing about here. Second, does the president take a different oath? The oath referred to in the 14th Amendment says says support the Constitution, whereas the oath that the president takes says to preserve, protect, and defend the Constitution rather than support it. So, you know, Trump is saying, you know, I didn't take that oath. That's the oath that members of Congress take. The Colorado Supreme Court said, yes, you did take that oath. It does specifically mention that you have to defend the Constitution. Number 3, did Trump engage in an insurrection? Trump is saying, no, it wasn't an insurrection. It was well, in fact, we heard this in the arguments this morning. It was a mob. It was a riot. It wasn't an insurrection. It was a riot. And, you know, on the other hand, what Colorado is arguing is that it was clearly an insurrection. It was an attempt to stop an election. It was an attempt to change the leadership of the president, you know, the presidency of the United States, the person sitting in that office, and therefore that is clearly an insurrection, and the Colorado Supreme Court agreed with that. And then finally, is Congress required to enforce it? Some parts of the Constitution say, you know, for example, the Constitution says Congress can make laws respecting trademarks and patents to further the useful arts and sciences. Well, that clearly says Congress has to make a law to put this into effect. Does this Section 3 of the 14th Amendment require Congress to pass a law to enforce it? Congress has never passed a law to enforce it. And the argument that the Colorado Supreme Court made, and that is being made before the court now, no, not the case. It's self-executing, and the proof of that is that hundreds of people were prevented from holding public office back in the 1860s, 70s, and 80s under this provision. So that's what's going on.